We have Ms. Kopech and we have Ms. Turner. Okay. Ms. Kopech, are you ready to go?
I am, Your Honor. Thank you. May it
Will you reserve 5 minutes?
Yes, I would actually like to reserve 4 minutes for rebuttal.
4 minutes it is. Okay. Please
Thank
proceed.
you, Your Honor. Thank you, Chief Judge. Good morning to all three of you. May it please the court. I'm Alice Kopech on behalf of the appellant, Nicole Nachman. Due to the severity of the error in depriving Ms. Nachman of a defense, I would like to focus, I'm primarily planning to focus on issue 1 in this case, in this oral argument, unless the court has questions on other ones, or if I have time. But it's clear in issue 1 that the foundation for the court's ruling in denying the self-defense battered child syndrome instruction as it related to Robert Deans rests on numerous erroneous findings. First off,
Ms. Kopech, if I could just ask a question or two, because this was a very, first of all, I appreciate your brief. This was a very serious, tragic situation, but a very intriguing legal issue. And what I understand is that you are endeavoring to raise the battered child syndrome self-defense against the stepfather. And I just want to be clear, because as I read your briefs and the record in this case, there was no evidence that I saw of any actions on his part in any way to be aggressive towards her or in any way psychologically or physically harm her. And first of all, is that correct? Am I right about that?
Directly, I believe that's correct.
Yeah.
I think
and your argument basically is he failed to protect, right? He's an enabler. He allowed this to happen. Okay. That's correct. So, and you've made this very interesting parallel between child abuse cases where an enabler or a failure to protect parent can be prosecuted criminally on a child abuse case, correct? That's the parallel that you've drawn, is that right?
That's correct, Your Honor.
Okay, and I'm pretty sure I'm right about this. There's no case in the country right now, anywhere, that you could point to that say, see, they did it here, so you should do it here. Am I right?
I believe you are right.
Well, that doesn't mean that doesn't mean you have a bad argument. I mean that means you have a novel argument, and that's kind of my point. This is a novel argument, case of first impression, and you're trying to make this parallel that I very inartfully served up to you. Is that right?
You're correct. You're not correct on the inartful, but yes, you're correct in how you present it.
So I'm gonna get out of your way now that we've sort of focused it. Take it from here.
Okay, and I think many of this, because it is novel, it's novel in the sense of what we were asking the court to do, but it's not novel when you look at all the precedent of battered child syndrome, battered spouse syndrome, to analogize to this is the rationale behind the principle for battered child syndrome, and that's what exists in this case, because obviously it's a self-defense case, almost kind of an imperfect self-defense case, that we have to look at the perceptions of danger of a battered child. And we know that the court allowed the battered child syndrome self-defense as to Mrs. Deans. So she did meet the criteria for battered child syndrome.
Ms. Kopech, I'm sorry, I appreciate you framing it in response to Judge Morris's questions. What troubles me, and I appreciate your advancing the novel theory, and I think I understand it and appreciate your confirmation on it, but part of what troubles me about your trying to make this rule in this case is that there's no evidence that Mr., I don't know how to pronounce his last name, the stepfather, ever did anything except enable or sort of benign neglect. There was no affirmative violence towards the defendant. And at the time, and so I have 2 questions for you, really. One is, if we're talking about passive neglect, I'm troubled about how we would make a rule that type of neglect could be, the deadly force could be used. And the second part of my question is in this, on these facts, and this is what I was driving at when I started my soliloquy. Miriam wasn't even anywhere near the house. She was out of town the night that the defendant shot her stepfather. And so it's hard to tie those facts, in my mind, it's hard to tie those facts up in a way that would let us honestly and faithfully to the law try to craft the extension of the rule that you're advocating. So could you address that for me, if my questions make sense to you?
I hope it does. I'm going to try, and if I'm not, then please let me know, and I will clarify. But I think the issue becomes that Robert Deans, there's no evidence that he physically or directly did anything to abuse Ms. Nachman. But the crux of what the judge was looking at was like, is he a legal parent? I think it seems clear on this record, if Ms. Nachman's parents had stayed together for all of these years and her mother severely abused her and her father did nothing to lay a finger on her, but also did nothing to lift a hand, then
Ms. Kopicka, can I ask you a really quick question here? Because this has been bothering me also. I don't recall any evidence in this entire record that he was actually physically present when the mother did anything either psychologically or physically to this young woman. Am I mistaken about that?
Well, and unfortunately, because he's gone, he would be the only one to corroborate that. Even all of the family members said they had such limited interaction with him. Ms. Nachman's brother had only met him 2 or 3 times. And all of the action, all of the testimony was that Mr. Deans essentially did whatever the mother wanted. She was rough on him too.
But
whatever
we don't
she
know
said,
whether he was standing there when the mother would belittle Ms. Nachman. We don't know if he was standing there when if she pushed her or threatened her. We just don't know that, right? And he was a stepfather who never adopted this young woman. So we don't know if he was around or not, right?
Well, she lived in the home. I mean, there is evidence, obviously, in the record that she lived in the home for nearly 10 years, unless she was away at college or she did get sent to boarding school, right. That she lived in the home and they resided. And the state even said in arguing against severance that this was, that this was a familiar situation of a family living under the same house. The state argued that against severing these cases. So even the state was saying this is a family unit. And not even just the family members, but schoolmates of Ms. Nachman who never saw her interact with Ms. Deans also were aware that Ms. Nachman was terrified of her mother and that all she wanted to do was try and please her mother and never could. So it seems to defy logic that Mr. Deans wouldn't have known that as well.
Yeah, but there's no direct evidence that he did. You've got a defendant who had gone off to Florida State. What we're losing sight of is she's away in Tallahassee most of the time and comes back and has this perceived fear that she's going to be killed by her mother because she couldn't get a dorm on time. And we don't have any direct evidence of the stepfather laying a hand on her. And what actually happened that night is she shot him in the back of the head. The only thing she said about it was he didn't give her any Chinese food. So let's just start with the premise of self-defense. There is no imminent fear of great bodily harm or death at all. So for us to transfer battered child syndrome to a stepfather that your co-counsel below agreed he didn't have a legal duty to take care of her because he didn't adopt her, that is stretching the law way farther than we need to stretch it.
And Your Honor, there was so much you raised there that I'm probably going to miss a few things.
Was any of it untrue?
Well, No, but I think it all needs to be placed in context.
Well, that's what I'm trying to do, because I'm putting this in context, because she did not live at home with her mother shortly before this. She's living in Tallahassee. Yet when she comes home, she shoots mom 3 times and shoots dad in the back of the head.
Number one, Your Honor, not at the time of the offense. She was living there, and she had been living there except for going to see her brother for that summer. And I think the way that you had said, the way that you remarked about, because she didn't get a dorm, she thinks that's not rational. I understand that's not rational. The whole reason why the defense exists in combination of self-defense is to explain unrational behaviors. That's if we had traditional self-defense, you would never need an expert to testify as to battering and its effects and what it does to the psyche of a child and their perceptions of danger. And so, and I know the state, you had mentioned some about because he didn't feed her, and the state said she was angry. There was no evidence she was angry. Dr. Heidi, the world-renowned expert in battered child syndrome, said she was upset he didn't feed her. That was a telegraph to her that he doesn't care about her basic needs, that he doesn't, and he never has.
But
and so that
Ms. Kopech, the problem is that we're talking about self-defense. And we have to recognize in this context, attenuated as it is with the stepfather and the lack of evidence of anything him ever doing direct, that the level that, what is neglect, is a history of benign neglect a sufficient threat to warrant the use of deadly force because he didn't order Chinese food for her? Or is there some other part of this record or your legal argument that would give us a little more purchase? I mean, your client raised a general insanity defense, if I understand this record correctly.
Yes, that's correct. But none of our, I mean, at least this issue isn't really focused on that, the self-defense. But again, I'm not focusing on just the Chinese food. We're talking about her state of mind and why she would fear that she was going to be killed and it was necessary to kill or be killed. And yes, so I understand that mom is away, but the neglect, and I know the focus, that was one of my foundations that I believe is an erroneous foundation, that because he wasn't responsible for her mental or emotional well-being, that's incorrect. I mean, the law recognizes that somebody who takes on a familial role, even a caregiver, has a responsibility for even emotional well-being. And so as a passive parent, then he had taken on that responsibility. They lived as a family unit. And the imminence, and I did cite the Ohio Supreme Court, where saying this expert testimony is necessary to dispel the myth that non-confrontational killings cannot satisfy the elements of self-defense. And so at the time that she's doing this, she has a legitimate fear that she is going to die. And she knows that Mr. Deans has never protected her, and either he'll let her mother do it or he'll help her do it. And that is a legitimate fear. And the whole neglect, I know the state had said, oh, it's absurd to say neglect, but the only world-renowned expert that we had testifying in here said that in parricide cases of severely abused children who killed their parents, there is a pattern of abuse, and almost always there is neglect, because if there is another parent, they are not protecting the child. And so Dr. Heidi, who is talking about battered child syndrome, and that's why she says it does apply to Mr. Deans, is because all of this debilitation and all this pattern of abuse was happening while she lived in his home. We're not just focusing on the time of—
Ms. Kopech, let's just take a hypothetical. If Miriam had been in the home on the night that the defendant shot Mr. Deans, would your case be better?
Oh, no question, Your Honor. Yes, no question. I would have to concede that. And I think that's what—
And I appreciate you've done, I'm not trying to belittle your case. I agree with Judge Morris that you've done your briefing on this issue, we appreciate it. But just trying to smoke out the facts that we have to work with, and how what you're asking us, what I think is a real stretch, to shoehorn into a self-defense rule here on these facts.
Right. And that's why
I appreciate your concession on my
yeah.
hypothetical.
And that's why I had cited the Ohio, or no, I think it was the Jane case when it was talking about imminence. It's the definition of it was.
In that case, there was active abuse with the other parent. I mean, there are some differences. There are differences between Jane's and this case. You're asking us to extend the rule of Jane's.
Well,
Ms.
right,
Kopech,
because
just so you know, you got 30 seconds more until you're at the time you wanted to stop at. Okay.
Seconds.
Yeah.
Okay. I went down some rabbit holes here, but certainly in Jane, I was also focusing on that was the judge was essentially saying, do you have any cases where it's not a parent as a batterer? And of course there are. It is the person, it is the battering, and why. And I don't think it's much of a stretch. I appreciate the way that the court is looking at it, but I don't believe it's much of a stretch to try and extend it to a passive abuser. That is what they are called. Passive parents are passive abusers because in enabling it, they are contributing to battering and its effects. And when we look at the cases that say passive abusers can be prosecuted, well, then why can't they have some liability that says you created the psyche of this child by enabling this? You created the psyche of this child, the wounds that scar the mind, that made her have the perception of danger that she had as a battered child. And I guess I'll reserve the rest of my time for.
Okay, you'll have 4 minutes. Okay.
Thank you.
All right. So, Ms. Turner, it's your moment.
Good morning, Your Honors. May it please the court. Getting into this whole issue addressed by my colleague, which alleges that the trial court abused its discretion in precluding that battered child syndrome evidence as to the murder of Robert, I want to point out that battered child syndrome is not a standalone defense in Florida. It's only admissible when it's relevant to support a self-defense claim when the defendant is charged with a crime against her abuser. So there were really two barriers to the admission of the evidence in this case that the trial court appropriately recognized, and as Your Honors have really touched on here. First is that there was no evidence of self-defense as to the murder of Robert. The defendant's own admissions after the
Ms. Turner, if you don't mind, I want to interrupt you just to ask you a question. Ms. Kopech has made a very compelling argument. It's abundantly clear in this case that this defendant, Ms. Nachman, was mentally ill. It's abundantly clear that she's had mental health struggles her whole life. Everyone that testified about her, who knew her, testified about things that, that evidence, mental illness. And so we do know that there is this corollary that you can be a parent or a custodian of a child can be charged with child abuse, child neglect, if they were an enabler, if they were passively not protecting a child from another parent or custodian who was harming the child. So I would imagine that your position is obviously that doesn't apply here. And we know that this is novel. Do you agree that it could not ever apply?
I think that would be an incredibly slippery slope. And there are really a number of things in the way of that applying in this case. But importantly, where we're at now on appeal, I think it's really important to consider the standard of review that this court is going to apply, which is the abuse of discretion standard. And
that really wasn't my question. That wasn't my question. I'm focusing on this defense, which Ms. Kopech has raised, the battered child syndrome defense of a passive parental figure or custodian of a child who is an enabler, who allows abuse to occur. I'm taking it out of the appellate context. We have no cases that actually in this country that right now would say, yes, we recognize this. That doesn't mean this is a bad idea. It just means it's a novel idea. And some of the best cases that have ever been written in legal history are about novel cases that someone like Ms. Kopech had the courage to stand up and say, we've never done this before. but we need to look at this because we should be doing this. So my question to you is, do you think this defense could ever stand?
If we remove all of the facts of this case and we're talking solely hypothetically, I could possibly foresee a situation where that argument would carry more water than here, because the basis of the battered child syndrome evidence it's a PTSD claim. So it's to explain the sense of imminence that a child of abuse feels when maybe there was no threat of harm imminently facing the child. So perhaps I could maybe see that arising, and I do appreciate the novel approach to the issue, but
I mean, we've applied this concept in a variety of other circumstances, so it's not far-fetched. I mean, frankly, it sort of looks like it should be part of the constellation of these other circumstances that we've talked about, and it's notably missing. So that's because I know your position is in this case it doesn't apply, and of course in the posture we're in on appeal, she shouldn't win, that you should win, and I respect your arguments on that. And I also appreciate your candor of recognizing that this is not a far-fetched concept. This concept has value. Question is, does it have value in this case? And that's what you're all about in your argument here.
right, there's a lot of things standing in the way here, given that, I mean, in your hypothetical where this defense could maybe apply, it would certainly involve a child who's being physically, brutally battered by the parent, and then the neglect of the other parent there would be some evidence, which we don't have in this case, that that parent was there over and over and over again.
So I'm going to ask you, Ms. Turner, the same question I asked your opponent. What if Miriam was in the home?
I think the evidence would be closer, as Ms. Kopech has conceded, but it would not get there in this case because by the appellant's own admissions, and again, this was a case where she didn't testify, and I believe a lot of the other cases that my colleague relies on involved cases where the defendant did testify. But there were only 3 instances of physical abuse that were recounted by the defendant, and there may have been more had she testified, but there was no evidence that Robert was present for any of those.
Well,
so,
the abuse wasn't limited to physical, though. I mean, I think this record shows that the Miriam, I don't think there's any real disagreement that Miriam probably promulgated a fair amount of psychological abuse on this defendant, and that's part of the foundation for the claim, and that Robert watched it, that he was aware and enabled that psychological abuse. Am I wrong about that?
there was a fair amount of evidence to the verbal and psychological abuse that was presented by the defense. You're correct. And
I mean, Nicole was afraid that her mother was going to kill her for messing up the dorm room by the defense's story.
Correct.
And that's pretty profound psychological stress.
Sure, but that also leads to the point that there's still the self-defense component to the claim, and that's, I guess, could be considered my harmless error argument, would be that even if that battered child syndrome evidence should have somehow come in this case as to Robert, the appellant really can still not meet that self-defense standard because it is an objective, reasonable person standard. And no reasonable person would fear imminent death or great bodily harm when facing the circumstances that she faced at the time that she shot her stepfather. This was an execution-style killing, shooting him once in the back of the head. The crime scene revealed no signs of a struggle. She was alone in the house with this man who, by the record, reveals that there was no evidence of abuse by him, no even allegations of physical abuse or even any other type of abuse. Simply that he sat by while Miriam, who's the source of fear, was hours at least or days away in Jacksonville at the time that she killed him. And she had a means of leaving the house, but didn't. So given that she can't meet that self-defense standard, and given that high abuse of discretion standard that must be shown to keep the, or to demonstrate error in this case, this court should affirm.
Okay, is that it, Ms. Turner? Okay, thank you.
The sole issue addressed, so yes.
Okay, Ms. Kopek, you have 4 minutes.
Okay, thank you, Your Honor. I think I want to start off with the premise that the state just said self-defense, it's an objective, reasonable standard. It's a standard that, as the defense argued below under Mobley, continuously raised Mobley, it's the reasonable standard with the defendant's subjective perceptions of fear. And so that's why these aren't traditional self-defense cases. The state keeps relying on essentially self-defense. Well, if this was a traditional self-defense case with a threat to Ms. Nachman, well, then you wouldn't need an expert to assist the jury in understanding stuff that, if they're not a battered child, they don't understand the actions that are most often irrational, of even why, the state had said why she didn't just leave. Well, everything related to the battered child and battered spouse syndrome talks about learned helplessness and explains why people can't leave, explains why there's an increase of aggression when objective people who don't suffer this wouldn't understand that. That's why the aid of an expert is necessary. And of course, the trial judge here recognized that in many of the cases that he had read about, mostly he was talking about battered spouse syndrome, he recognized that aren't they often non-confrontation killings, like the husband is sleeping at the time of the offense? That threat isn't immediate, it's imminent. That's what I think the Ohio court, or maybe it was the Jane court, was talking about, that threat hanging over your head of what's going to happen when this person arises. One thing, and so that, and this court in Brewington, the state itself argued when a woman who was getting prosecuted for manslaughter was trying to say, hey, I suffer from battered child syndrome. And they said, no, battered spouse syndrome is an aggressive action that's taken, and most often when there's no actual threat, like objective threat facing you. That's what the state argued in Brewington, recognizing that's why this is, the defense is or I should say the combination of battered child syndrome with self-defense is meaningless if we just go to the objective standard. And Judge Sleet, I did, when I said, oh, there's so many things in there, I do want to correct one thing. When you had mentioned, didn't the appellant below agree that Mr. Deans didn't have any legal duty? I would submit that no, she never did. She constantly said Mr. Deans had a duty to protect. That was in a very...
Actually, I think they made that concession to Judge Sabella during the motion hearing.
Well, I disagree that it was a concession. That's just what I want to clarify. That was
what they did was they argued there's no precedent to show that he has a legal duty. So then they started talking about your cases, such as Brewington and other cases where they're babysitting maybe a minor child, the boyfriend, the girlfriend, things like that. But we have an adult defendant here. I appreciate the complexity of this case. Truly, I do. And it's tragic. It's just tragic. But it's a little difficult when Dr. Hyde herself even admits that she did not have any evidence of any abusive acts by this stepfather at all. And so when the offense does occur, it occurs the way that I described it, and your client jumps out of the window after cleaning up the scene. So I know you're talking about irrational behavior, but cleaning up the scene is relevant for state of mind. But she cleans it up after killing him, then kills mom and does nothing. Doesn't clean up, doesn't do anything. She just runs away. So it's a little tough for you. I get it. I appreciate your situation, but I don't see any legal basis for transferring it to someone in his stead who did not abuse this child. He didn't make her get the liposuction. He didn't fat shame her, so to speak.
Ms. Kopek, you're well over your 4 minutes, and Judge Sleep took most of that time.
Sorry.
So I'll let you respond.
Okay, I'll just respond to that question. I just want to clarify again that there was no concession that he didn't have a duty to protect her. When she was mentioning, no, I don't, she said she told the judge, I'm trying to refer to your analogy of a law enforcement officer appearing on the scene, the court was focusing on the time of the offense, not the time of the abuse. If a law enforcement went to apprehend her, would she be able to? I mean, certainly if the facts were that a law enforcement officer consistently, as a pattern, because we need a pattern, watched a child be abused and did nothing, we're talking about a different thing. But the judge was focusing on the time of the offense and not the time of the abuse, which, you know, she was a child when this abuse started, and it continued all the way through with 10 years of her life with Mr. Deans in it. And so I know I'm way over my time. I appreciate you allowing me to answer that. I would just ask that you reverse and remand.
Thank you both very much. This is obviously a tragic case with a fascinating legal issue. Really, we could have spent the better part of today here talking about it, but your briefs and your arguments have helped us a lot, and we appreciate it.